Every day in the USA, people find themselves in court.
In Washtenaw County, a former church youth director is facing multiple charges, including criminal sexual conduct and child pornography. Thank you for joining us for CBS News Detroit at 5. I'm Terrence Friday.
I'm Shayna Humphreys. Police say the alleged crimes date back more than a decade. CBS News Detroit's Jack Springate is live at the Washtenaw County Courthouse. And Jack, I know you've been talking with leadership at the church. What are they saying about all of this?
Well, 29-year-old Zachary Radcliff wasn't just an employee at Oakwood Baptist Church. He's also the son of the senior pastor there. Michigan State Police have identified several victims following a search of his home and office, and they're asking any additional victims to come forward and share their stories. The investigation has identified multiple victims. Leadership of the Oakwood Church have been cooperative and transparent throughout this investigation, MSP said in a news release. The investigation alleges Radcliffe's victims were between the ages of 12 and 17 at the time of the crimes that had been occurring as early as 2011. Oakwood leadership placed him on paid leave on October 3rd before fully terminating his role with the church on October 12th. Oakwood operates out of the Lincoln Community Methodist Church they've rented since 2021 as they make plans to build their own facility. The lead pastor at Lincoln tells me the two organizations have no affiliation outside the rental agreement.
This is a solemn reminder that every congregation or organization dealing with children should regularly review and update their child protection policies, and I let them know that we will be doing just that.
Oakwood issued a statement to their congregation saying, quote, "The information that we received was shocking. We were told that Zachary had been soliciting inappropriate photos and possibly videos from teens. We've also heard other stories. This information has ripped our hearts apart," end quote. They pledged to provide counseling for any members of their congregation that felt the impact of these allegations, while directing any additional victims to reach out to the MSP post in Brighton. Radcliff is being held on $3 million bond, and he's scheduled to return to court on Halloween for a probable cause hearing. Reporting live in Washtenaw County, I'm Jack Springate, CBS News Detroit.
All right, thank you, Jack. We'll keep following this.
People's State of Michigan versus Zachary Radcliff. Counsel, state your appearances, please.
Good afternoon, Your Honor. Amy Reiser, appearing on behalf of the people.
James Thomas for Mr. Radcliff, Your Honor.
All right, I guess the first order of business is there have been added counts 12 through 33. Counsel, I presume you've been presented with.
We just got it yesterday, Your Honor.
Yes, because they were sworn out yesterday, so you would have gotten it. I want to just make sure, because of the way that counts are done. The copy, you got that from Ms. Reiser?
So put it electronically emailed.
Got it. So, but it was the one after it's sworn out with the adjustments we had to make to the count 11.
Correct. So the original complaint information contains counts 1 through 12. 11 was not sworn out by the magistrate, so 11 became count.
11. Well, count 12 became count 11.
So in the amended complaint, the people added counts 13 through 33.
Correct. So, counsel, what you ought to have, that sounds all confusing, but it has to do in part with our case management system. So when the original complaint was sworn out, count 11 was not authorized. Count 11, based upon the testimony, is now count 33. But when those original 11 charges went in, they have to be numbered sequentially in our case management system. So count 12 at the time of that is actually now count 11. And then yesterday, what was sworn out were counts 12 through 33, which are actually additional counts from, if that makes sense to you.
As I said, Your Honor, yesterday, I just got it yesterday. I made copies of everything I could make. for my client to give to him. What I don't have in here is I actually don't have the actual accounts, and I printed.
You don't have
Either I missed it or the four items that were emailed to me don't have the counts in them.
you don't have the amended, so you're telling me
I-
right
I-
now you don't have the amended complaint?
I have my phone in my car, but I
Well-
have the email and I'd have to look in there because I downloaded the 4 attachments last night and I printed everything. And
Okay.
everything
So-
I printed is right here and I don't see the amendment in here. So
You don't see the amended complaint?
not in
So
my,
you don't, so just so that I'm clear, because I want to make sure you have
Yes, sir.
everything, you don't have an amended complaint that has counts up to count 33.
I don't have them here, so I have not seen them, Your Honor.
Got it. Okay, so what I'm gonna do,
And obviously they're in my email. If they were sent, they would be there. And what I'm saying is that I downloaded those 4 files that they gave me yesterday and I printed each one of them, but it's not in here. So I either printed it and did put it in or it's not there.
gotcha, fair enough. So what we will do is we'll give you a copy. That's the amended complaint. And what, for quick reference, what I'm referring to is if you turn to the 3rd page, and in looking at count 11, from the complaint that you originally had, count 11 should be identical to the count 12 that you had before.
Okay.
Right? It has now become count 11. From count 12 through 33, those were the ones that were sworn out yesterday. So those are all new. Well, yes, those are all new to this amended complaint with one caveat. Count 33 is really what was count 11 with additional information. And I know that makes it even more complicated, but
I'm just making notes, Your Honor.
okay, no, that's fine. So one thing I'm a little bit worried about, if you, it doesn't, well, it matters to me, but if you didn't get it, then you weren't able to share that with your client.
That's correct, Your Honor. We
Right.
can talk about this today, no. I
And
met with him already for 2 hours earlier.
because one thing that I have to do is I have to arraign him on counts 12 through 33. But if he hasn't seen them, don't know what they are, I don't know how productive that would be to try to do that. I can do it one or two ways. I can take a break, you can go back there and talk to him and go through each one. Or however you want to handle it.
Yeah, if I'm allowed to do that.
Yeah, what we'll do is I'll pass the matter. We can take him back, you'll have to go around, but go around and then you can go through each one. Okay?
Is
all
it the same thing to go downstairs?
No. Everything will be up here. He's up here, so he'll just go back and then we'll show you where to get in and out.
Thank you, Your Honor.
All right, thank you, sir. Court will pass this matter. Court does. It's called the case of King versus Radcliff.
Amy Riser.
James Thomas on behalf of Mr. Radcliff.
Your name, sir?
Zach Radcliff.
All right. Counsel, you had an opportunity to go through the amended complaint on this case.
I did, Your Honor.
All right, as to counts 12 through 33, as to the arraignment on those counts, do you waive formal reading of those counts?
We do, Judge.
And your client wishes to stand mute to those counts at this time.
I'll plead not guilty.
All right. Defendant having waived formal reading, pleading not guilty, court will enter those pleas as to those counts. All right. And now what are we doing today on this case?
You asked me or the prosecutor, Your Honor?
Either.
We can,
Well, we're set for PCC, so what do
we
we?
can continue to exam, we can set another probable cause conference if council wants. I'm at his leisure.
Judge, I have no problem going forward on the preliminary examination, but I do have a few things that are that need to be addressed. And I think for the purpose of the court to know, and I'll just give you an example. I haven't looked into count 13 through 33 at this point, obviously, but going back to count 1, which is the first allegation that accuses my client of first degree felony, is from a person who was allegedly 13 or 14 or 14 or 15 at the time that it occurred. And it makes a big difference in regards to my client, because if she was 14, my client was 17, would have been a juvenile. Or if she was 15, he would have been 18 and would not have been in the state. He would have been in college in Virginia. So what I'm saying is that those first 12 counts really don't have any specificity as in regards to, and I've asked the prosecutor, she said she was going to kind of connect the dots for me for who the alleged victims go with what counts. But that first count is kind of bothersome. On top of that, allegedly there was an FBI complaint that was made by that person in count 1. And there was a report taken by the FBI that I asked prosecutor. She said she doesn't have in her possession, but I brought it to her attention today in court that if there is an FBI report, that I would like a copy of it. Obviously, we deserve to have a copy of it. If it was actually taken, there would be a report number by the FBI. There would be an interviewer. There would be a statement. There would be a report filed. And obviously, we would like to have a copy of that if it exists.
Well, okay, if I can just stop you there, and
Yes,
I'll let you go on, but have you made attempts to obtain that report from the FBI?
I have
It
not.
exists.
I have just found out today, Your Honor. Just found out today. I just found out today. I also found out that his phone that was confiscated has some exculpatory evidence on it. That's been seized. My understanding, and from reading all these reports and stuff, and I'm just not to be disrespectful to the author of the reports, but it's really all over the place. It's not a very good written report. There's things that are just all over the place. But one of the problems that I'm seeing in regard to that, judges, there are things that have been either just overwritten or not in there, the detail and whatnot. I'm not faulting, because there's a lot of different people that are allegedly involved in this, but just trying to get through the different aspects of the report and who goes with what. It's all clustered in, and trying to figure out what charge goes with what person makes it very difficult. Even on just the 12, now we got 33 counts to contend with, to try to figure out what goes with who, and the timelines, and whether we're going to have alibis and all that kind of stuff. And there's just the times, dates, and things aren't there. The other thing that is that we're looking at is that they've sent out subpoenas to all these different places, the Snapchat, Yahoo, Gmail, all these different things, to try to get all this alleged evidence that they are talking about that was sent back and forth. Because we're talking about computer crimes that have video, audio, text messages, emails, all that. We don't have any of that in our possession. I don't know if they don't have anything, but in reading the reports, I'm not getting that they have any evidence of any of these allegations, other than just an oral made statement from an alleged victim to the cops saying, yeah, this happened. I don't know when. It was, I was 15 or 16. It happened quite a few years ago. And that's what we're contending with. We, as a defense, have to be put on notice of time and dates, places to be able to create a defense. It puts us at a very unfair advantage without having any of this information, other than, for better lack of word salad in a report that doesn't give us any of the details of when these events, where they occurred, how they occurred, or any of that kind of stuff. Just an allegation that these things were done, and then they were done through a text message, through an email, but yet we don't have a text message. We don't have an email. We don't have a video. All these things that have been alleged are not being produced, or they don't have them in their possession. So what we really have is we just have people that have gotten together, that have made these arguments and have made statements and allegations that the prosecutor has filed charges on. And we're not on notice of any of this stuff. And I think that, for purposes of going forward in this case, I mean, I'm happy to go forward. I'll do whatever the court wants me to do. But if we do a preliminary examination, obviously, if they're going to put their victims on the stand, I'm going to cross-examine them, and they're going to take a while each one that they put on there. I'm counting at least 7 or 8 people, possibly, maybe more. I'm not sure how many are there. Notwithstanding the fact that I think that these charges are not related. Some of them are not related at all, and they need to be severed out. They're not. You can't just lump all this into one case and say, you're going to go to trial in one large conglomerate case. That's not the way. These things, from what I'm reading, happen at different places, different times, different, allegedly, and didn't happen at the same time.
But
So,
at least as I understand it, these are, and certainly I'll let the people speak for themselves, but these are tied together really by your client's position vis-a-vis the.
I don't know until we get to the preliminary examination.
Well, right. I mean, but at least, I mean, you're telling me that, and certainly that can be true in certain circumstances, but.
Well, just for an example, Your Honor, count 1 is from 13 or 14 years ago. Some of these other counts are from from 2019, 5 years ago. So obviously it's two different times, places, and dates. I mean, it's not.
Well, right. I see what you're saying, but if I take it out of the context of what may be this case, if I had an educator or a teacher and they've been employed, say, at a school over, say, a 15-year period, but may have been engaging in similar conduct throughout their employment, that can be one case if that's what's happening. Now, again, I'm not saying that I know that that's what's happened in this case, but that is, at least as I'm to understand what was really occurring, is that that's what frames this as one thing.
Right. And again, if we go through a preliminary examination, the court finds that these are relatively relevant in that aspect, and then that would obviously be the court's decision to do that. I'm saying that from what I've read and what I'm seeing, I think that there is going to be severability on some of this stuff, maybe not all of it, but some of it. And, obviously that's going to be up to the court to make that determination. Obviously, whatever gets bound over, if anything gets bound over, I obviously would make that same argument to the circuit court judge if I had to, because I don't think that they are going to be relevant in that aspect. Some of these involve boys, some involve girls, and
yeah, but I don't know that the gender of a potential victim is going to be a basis upon which to sever these counts. But certainly you can make whatever argument you make, but as I understand, there is a certain element that ties them. And I think that being as I'm to understand it, and again, I'm not saying any of these as though I necessarily know, but at least what's been represented, because I was sworn out the counts 12 through 33 when they were sworn out. What tied it together, at least in the court's mind, was your client's position vis-a-vis these individuals. So and that's all that I can say. I don't know that to be true. I mean, certainly, but that's what I understand.
And I understand, Your Honor, what you're saying, but again, I'm saying, if the allegations are 17 or 25, I mean, I certainly think that the circumstances are totally different between those cases. So that would be our position. I mean, obviously, I would need to do a little research, and now that I've got more more counts to have to get through. It's going to be up to the court. I mean, again, I would say if we're going to go from here to the preliminary examination next, that it's.
Well, counsel, the way that this court has functioned, particularly with regard to PCCs, and that's the stage we're at now, to getting to preliminary examination, I want to make sure that each side has what discovery is going to be necessary to go forth. So I don't, unless I have to, I'm not really in the position and don't like to just push people to preliminary examination if you don't have anything or have everything, because, you know, at least in this court's opinion, it makes it a meaningless process. But some of what you brought up, I get, but I don't, you know, I'm never sure what's there either. I mean, the exam were mine, then I'd have to sort all of that out. But Ms. Reiser has all the, I mean, let's start with, well, maybe the hardest one, but the easiest one. The forensics on the phone, that takes time. And I'm presuming, given the timing of everything, that the people don't have all of the forensics from the phone.
That's correct, Jenna. There were several search warrants executed and electronic seized from the vehicle that the defendant was in, as well as the residence and the church and the church office. So those items are being examined and they are not complete.
Got it. Okay.
But also I should say with caution, as in any of these cases, if it's password protected, it will take us some time to get into them. So if there's a phone or a computer device that has a password to it, and it may take some time, up to months, up to a year to break that.
And so then the question becomes, counsel, I think in that regard, so that you can be aware of what the court's position is and what the court's prior position has been. If there's a device that you believe has exculpatory evidence for your client, but the authorities are having difficulty getting into that device because of the password protection, then I'm going to let them do their work. If your client wishes to then give over the password so they can get in to expedite that process, then they're free to do that. So just so that you're aware of where this court has landed previously.
Yes, sir.
Regarding that. So, well, what it sounds like to me is that you're in a position, particularly now with these last counts and the 33 being there, attaching, and just so that I if I'm hearing you correctly, attaching individuals with particular allegations in the complaint.
I would like to know. I mean, I understand that they're minors, but I think that the prosecutor has a duty to at least say this, we're pinning this minor to count 12 and 13 or 14, 15, 16, to at least, so I know what I'm looking at for dates, times, places, or whatever. I mean, I could certainly file a motion for a statement of particulars if I needed to. I have no problem, whipping out a 5-minute motion and sending it in to be heard. But again, these are cordial things that the prosecutor should be willing to give to us without having to fight for them.
Well, sometimes it's funny when defense counsel comes in because I don't know if it's a fight. Has it been asked for?
Yes.
All right.
I asked her today. So,
well, okay, but if you ask for it today, what was the response? No?
No, I think that she will be, I'm just putting it on the record, Your Honor, because I have asked for it today. I mean, obviously, my client's incarcerated, and this case is already, over a month old at this point, month and a half or whatever it is. I mean, he's sitting in jail on a very high bond. And obviously, we're waiting on discovery from them to make a determination of a lot of what they give me is how it determines what I'm going to do. I mean, I can't guess what I'm going to do. I need to have some.
I get that, counsel, but if you're just seeking to put this on the record, okay, fine. I mean, then there's not a response that I guess is going to be necessary from the court. I mean, if you ask for things today and their response were anything that you asked for, let me ask this question. Was the response, no, I'm not going to give that?
No, absolutely not, Judge.
Okay.
But I'm saying that was before she didn't know I didn't have the 33, because it got sent to the wrong email. So that's why I don't have the 33 count information. So I didn't get it sent to me. No fault of theirs. They sent it to the wrong email.
That's right.
And so I was unaware when I walked in here. I thought I was still dealing with counts 1 through 12. I had no idea I had count 1 through 33 until the court brought it to my attention. I was like, oh, that's a new one on me. So I had spoken to her before that. So I'm hoping that it will cover all the counts, what I asked for. And I know that it might be one of those type of things where she's saying, well, these are minors and I'm not going to, I don't have to put it in the charging document, but, I would like to have that information so I can at least, talk to my client, see what those dates and times cover.
Okay. So what it seems to me is that there's been no request that's been turned down. And
none of this.
Miss Reiser, my understanding is that everything that the people have at this point has been turned over.
Correct. And I did indicate to counsel today that I would send him the names associated with each count. Now I will indicate for the record, count 6, 7, 8, 9, 10 have listed victims. Those victims are all listed in the counts, as is count 1. Criminal sexual conduct in the first degree relationship, 15, 16, 17, and 13, 14, 15, 16, and 17. I've sent him the name that victim is associated with. It's not written in the complaint because the victim is a minor. And that's also supported by all the discovery that's been sent to him by my office, by our discovery clerk. So all of the information supporting that, the multiple penetrations of the victim for the CSE 1 counts are in the discovery that have been provided. And I thought, and correct me if I'm wrong, but at the last date, I indicated to counsel in the court that there were more victims coming forward and I would have this amended complaint done and ready to go by today's date, which I did do. So this should not.
Well, the last part of that, I don't specifically recall. I do recall you saying that there were additional victims and then presumably additional charges. So I do specifically recall that.
I have shared with counsel the names of victims that I have associated with each count that I would intend to show at probable cause that victim is associated with that count. In some of the charges, the child sexually abusive activity that we did persuade, induce, entice, coerce under the age of 18 to engage in a child sexually abusive activity. It doesn't call for a victim's name. It calls for a child under the age of 18. So I have charged one of those counts for each victim that he solicited them under the age of 18 to send images and videos of them masturbating to him. So there's one for each victim associated with each count. All of this information in the discovery, each victim, each location, and it does occur from 2014 through 2024. So when counsel's ready, I think the best thing to do is to have a preliminary exam. I don't know when the electronics will be done. He's advised that there's exculpatory information on one of the electronics, but if we can't get into it, I won't until we can get into it. He's requested a FBI report on page 11 of 17 of the troopers, what I believe to be a well-written report, indicates that he had contact from other agencies. On the morning of 10/17/2024, Special Agent Adam Christensen of the FBI Detroit contacted me about a tip they received from Holly on 10/7/2024. And so we'll obtain that from the FBI if we can. We don't have it in the discovery now, but if there is a report, I'll obtain it, and we'll forward it.
So just so that I'm clear, you're going to provide to him the names associated with each count.
I already have sent him an email with the names that I intend
Okay.
to associate with each count.
And that was sent
That was just emailed. You should receive it.
today.
Yes.
Okay, so everything's happening today. All right, that's fine. So that would take care of that issue. And then it would also seem to me, counsel, to take care of the issue regarding potentially at least some of the timing and other things, because that can then be tied up into reports, right?
Yes, sir. Hopefully.
All right, so what do I want to, what do you guys want to do today? Because the way we keep standing here, it's going to be Thanksgiving.
Can I have a second to confer with my client real quick?
Certainly. Counsel, yeah, you might want to step back from, or not. All right. Counsel.
Yes, sir. So if we had one more PCC just to go through all this stuff to make sure that we have everything that we need to be ready, could we do that? If not, we
Yeah, I mean,
I have no
Counsel, if you ask for an adjourned PCC, I know there are other courts around the state that they won't do it and whatever. I will adjourn the PCC. It behooves no one if the parties aren't ready to go. So if you need an adjourned PCC, I don't have a problem doing that. It's just a matter of what time you're looking at to make sure you can get through everything. And so.
I think that, you know, in light of the new information that we have, just so I can get it to my client, let him go through it, get some notes. I'm going to need some explanations, I mean, not that it's a problem, but I'm on the other side of the state, so I have to make my way over here to do that with him. So if I could just get a little time to get him that information in the new emails that were sent today, and I think maybe a couple weeks out.
Tell me when you want me to set it. I'm here I'm here today on Tuesday. I'm pretty much here every Thursday. The only Thursday, well, I know I'm here every Thursday. Okay, see you every Thursday.
I know, you're so lucky.
Okay. But then, so every Thursday, and then during the holidays, I have dockets like I have today where they're split in two because prelims are typically on Tuesdays. So, but I can give you however many weeks out that you need, counsel.
Judge, I actually really like this time because it gives me time to meet with my client beforehand and do it in the afternoon, plus my drive over here. So,
I mean, we can give you an afternoon time. That's not a problem, but I just need to get a date.
Tuesday or Thursdays?
Well, no, just Thursdays.
Just Thursday.
The only Tuesday that will, no, that's a Tuesday. I have 4 Tuesdays, all Thursday.
All Thursday for PCCs.
Now, from here.
From here until out, yeah.
Could we do
Any Thursday.
we do the 19th, Your Honor?
Absolutely. People have any problem with that day?
No.
All right.
So it'll be 2 o'clock again, Joe?
Well, here's what I do. Probable cause conference will be adjourned to December 19th, 2024. I set it at 9 a.m. What will happen is you will get a sheet that will set it at a later time. So typically you would be in the afternoon.
Okay.
Okay. If there are motions filed, our process is if there are motions filed that have to be heard, then that's going to get kicked to a 3 o'clock block. And then everything is heard at 3 o'clock, no matter what time you were set throughout the day.
Okay. So if I'm hearing you right, so if this gets set for 9 o'clock on the 19th, we'll get bumped till afternoon anyway?
You're probably going to be in the afternoon. It depends on how many I have. I typically do not have under 100 that I have to do. So private counsel typically goes later in the day on a regular basis, so that because of scheduling.
Very good, Your Honor. Appreciate it.
Okay, all right. So that's the way it works. And if there becomes a difficulty, you can always contact my office and we will try to work around that.
Yes, sir.
All right.
Yes, sir.
Is there anything else from either side?
No.
No, Your Honor.
No? Okay, thank you. Bond will continue.
Thank you. Can I be excused?
Yes.
Thank you.
Pardon?
Do I need to do anything with bond conditions on that file?
Oh, counsel, on the Radcliff matter, you didn't need any of the bond conditions changed, did you, Ms.
I
Rasser?
just want like, no contact with each victim.
Because I think victims may have been added, so I want to make sure.
No third-party contact.
All right, I have 6, 7. They do that. Anyway, it looks like I have 7 or 8 victims. So what I'm going to
Send email the names to your staff to confirm they're in there, or could you send me the bond conditions and I'll confirm it?
Sure, we can. Why don't we send the bond condition? That's probably an easier way to do that. And then look at what needs to be amended. What we can do, counsel, is we'll try to do that by email if it's going to be something. I would add, of course, any alleged victims to the no contact. So I would probably do that in any event. But if there's something that needs to be added that looks something different, we will keep you apprised via email, give you an opportunity to respond to us regarding that before I make my decision. Fair enough?
Yes, sir.
All right.
Thank you.
Court does call the case, People of the State of Michigan versus Zachary Radcliff. Counsel, state your appearances.
Good afternoon, Your Honor. Amy Reiser on behalf of the people.
James Thomas on behalf of Mr. Radcliff, Your Honor.
All right. Mr. Thomas, this is the defendant's motion, so you may proceed.
Thank you, Your Honor. Would you prefer me at the podium, or since I'm spread out here, can I do it?
Either way.
Judge, I'm going to start off with just talking about where we're at as far as this motion is. As you're probably aware, my client's been incarcerated for about 105 days at this point. He currently has a $3 million bond, which under the circumstances I feel is unreasonable. And I think that once we talk a little bit about what the evidence is in this case, because obviously part of our burden under the law is to show that there isn't a great amount of evidence, or that the presumption is great, that the evidence of guilt is there. And to go through that, Your Honor, what I'm going to do is I'm going to kind of surmise the evidence a little bit here from what we've looked at. And I would tell the court, as of just yesterday, I just received another supplement in regard to this case.
All right.
Of course, the last time we were here on the 9th of January, I believe that was the last PCC. The last time we were here, I had asked whether there was any other outstanding warrants that were involved or anything. And then I became aware that now I guess there's some Snapchat warrants. But at any rate, Your Honor, just to go through a cursory account of what I believe is not great evidence or a presumption of guilt in this case in regard to the evidence, simply would turn and talk about the FBI report that was given to us, where one of the victims in this case went to the FBI to lodge a complaint, which was really the beginning of this case. And upon a cursory review of that particular investigation that was conducted by the FBI, they found that they didn't have any Facebook or YouTube channel or Instagram. Everything was negative or for derogatory information in regard to that. Notwithstanding that, and again, this is me reading this report, that this allegations that were made were like multiple sessions that allegedly occurred. But when the investigation went back to the state police, it's one time. So there's a difference in that, and obviously there's no evidence of this years ago, over 10 years ago, whatever it was. So that was the beginning, which led into other things. Going into an investigation for Yahoo, and going into his email address, going into all these videos and whatnot that were alleged to have been passed back and forth between the different alleged victims and whatnot. There is no CSAM. So there's no CSAM in this case that is in my possession that I've seen at all. And obviously that's a problem, because back in November, as you're aware, there was a 12 count complaint that then turned into a 31 count complaint. And the magnitude of charges doesn't make this case any more significant. You can't continue just to stack charges when you don't have the evidence to prove that CSAM. They need CSAM to prove their case, and they don't have it. They don't have any of this stuff. So the presumption, the evidence of guilt is not there. And again, I'm going to get into the other part of the hurdles of this case, but it's not there. We don't have any of this stuff. Going to, again, looking at the Google ones that were sent out, nothing. There's no evidence in regard to any of these transactions that were allegedly occurring between the people that are involved in this case and the defendant in this case. Now, the court is obviously well aware that when you're charged with capital offense, obviously part of this for us to show that there's a lack of this evidence. Well, we got the response from the prosecutor's office yesterday in regard to our allegations in our motion, and I'm sure the court, I don't know if you've had an opportunity to review it or not at this point.
I have.
But here's the part that I have a big problem with, Judge. When 6, 7, and 8 are the meat and potatoes of our motion, which the prosecutor's office answers they can either admit or deny. And obviously, you can't admit or deny and then put that we need to show our proofs on this, totally shifts the burden to us. We don't have a burden. The standard of proof for us is nil. We have to prove nothing in this case, Your Honor. And I find it kind of, as a 28-year-old, I find that kind of disingenuous. The answer being either we don't admit or deny when you have a 31 count complaint that my client's facing with a $3 million bond that can't get out of jail. It's not reasonable. I just don't think that that's right. If you're going to deny something, that's fine. I don't have a problem with the denial, but not admitting and not denying as to the basics of why my client is incarcerated, I have an issue with. And so I want to, I hope that the court will take that into consideration, when considering whether or not we've met that, met the standard that this case does not have the evidence that it needs to continue to hold my client on a $3 million bond. The court was given, today, I don't know if you had an opportunity, because there was 11 letters that I submitted as a supplement this morning, Your Honor.
Counsel,
I
you haven't been before me, but I read everything. So yes, I've read.
Okay. And I appreciate that, Your Honor. I also, and I don't know if I showed this to the prosecutor. These are like 6 or 7 more letters. I don't expect you to read them right now, Your Honor, but can I approach you this?
Any objection to the court receiving the additional letter?
Judge, I have a copy of them. I can later on do another supplement and admit them.
All right.
To the clerk's office, Your Honor. So let's talk a little bit about the flight risk. And I think that, with the danger of the community and whatnot, the things that the court would be concerned about, obviously, to make sure that my client shows up for court. So we have all those letters of support, as far as my client goes. He is a lifelong resident here in Michigan. He's never lived anywhere else. He doesn't have a passport. He doesn't have, he's indigent.
Didn't he live in Virginia or no?
No, never.
No. Okay.
He went to school there, but when you're a student, you don't have to.
Yeah, but I mean, he was there at Liberty, right?
As
Or
a student,
no?
I believe, Your Honor.
Okay, okay. I just want to make sure that while he may have been a Michigan resident, there were periods of time where he resided out of state. Is that right?
It's fair enough. Yeah.
Okay. All
That's
right.
fair. I've always known it, whether you're in the military or if you're a student out of state, you're not really a resident of that state unless you claim to be a resident of that state. Because you don't have to get a driver's license from that state if you're either in the military or you're a student. I don't know if the court knows that or not, but I know
I attended school out of state. It may have been back with the dinosaurs, but same rules apply. Go ahead.
All right. Well, his ties to the community, obviously his family, friends. I mean, he has all these people that are sitting in these rows here in his support here today, Your Honor. I'm sure some of them that are here wrote some of those letters. He's not going to be a play risk. He's not going to be going anywhere. And, obviously I'm his attorney, and I'm going to be on this case to its conclusion. He doesn't have a history of any alcohol abuse or drug abuse or anything like that. He's never even used any of that stuff. There's allegations from some of the people in this case that he has, but there's absolutely zero evidence of that. And obviously, my client would obviously tell you that he does not have any issues whatsoever with any of that stuff. And he doesn't have a criminal record and no juvenile record in furtherance of that. So these are things that I think would be important, to the court. Obviously we feel that he could get a job doing something if he were to get out. He doesn't even need to stay in this county. He has a sister who lives in Lenawee that he could stay with if need be. And obviously the other thing would be, if he needed to wear a tether or something like that, he would be, he would do anything the court would require him to do. I'm also going to talk a little bit about, the risk, the outside risk to the community, and again, just because you file a magnitude of charges on somebody doesn't mean that you can file 100 charges on somebody. If you don't have the evidence to prove those, you can't just say, well, the magnitude of charges merits a high bond. That's ridiculous. It shouldn't work that way. Bail doesn't work that way. I would also cite the court to a case, which is the People versus Davis. It's a Michigan Court of Appeal case from 2021. Basically, that under Michigan law and under the Constitution of our state, that you have a right to reasonable bond and reasonable bail, and based on your circumstances. And my client's indigent at this point, so a $3 million bond is tantamount to zero bond. I mean, even if it was $1 million, it's still tantamount to no bond. Lastly, Your Honor, I'm going to talk a little bit about, we had an evaluator go in there, psychology, Dr. Schaefer, Kathleen Schaefer, who I believe, and I'm not from Washington, but my understanding from my communication, unless I'm wrong, that she's been a doctor for the prosecutor's office also, and so in Washington. I don't know if that's true or not, but I believe that that was something that she proffered to me. But she's also went in and saw my client. I attached the 4-page report. I'm not going to go into the report read it to you or anything. But obviously, he's a very low risk for for repeat violence. She scored him as low on everything, pretty much, Judge. And obviously, we had that done for the reason of this hearing. And I think that that taking that into consideration, the court can certainly take other other measures to make sure that if he were released on some type of bail, that no contact orders and all these other things that the court has an absolute right to implement and put on my client to make sure that he's going to not only comply with the court's orders and showing up in court and doing what he's supposed to be doing while this case is ongoing, but also, obviously it would be a great help to go through this evidence and prepare for this case, in the upcoming court date. And that's going to be very important to our defense and being able to be properly prepared to defend this case. And again, Your Honor, just looking at the evidence, I submit to this court that you can point a finger and collaborate and do whatever you want, but just pointing the finger, it's just an accusation and accusations where the investigation that was conducted in this case with all these things that were supposed to be passed back and forth, that not one thing has been passed either from him, which would also, which I didn't bring up, but which also would include a VHS, a camcorder, 7 VHS that were found in his house. And he had no time to try to hide anything or clean anything up or do any of that stuff. His house was search warranted, and they went in there and confiscated all this stuff and still didn't find anything. So on top of that, Your Honor, I would just say that, obviously, if the people that are making the allegations said that they sent things through ISPs or IP addresses and through their email or through that, and yet the prosecutor's office has had the opportunity to do all these things, subpoena all these records, try to get all this up and not be able to produce one piece of solid evidence and then say, well, we don't admit or deny to any of these allegations. It's because they can't, because they don't have the evidence. So, Your Honor, I'm asking the court today that, what I would think would be a reasonable bond for my client would be, $10,000 in that range, and possibly, he would be amicable to any of that, Your Honor.
All right.
Thank you.
And
yes, sir.
had a couple quick, and so that you understand both parties, sort of what the court's analysis and looking at the issue of danger to the community and the flight risk. When I go through the prosecutor's response, some things kind of jump out at me. One of those being, there was a lot that kind of jumps as it talks about the particular victim. But when the behavior as I see it laid out is certainly, and I know they're going to have to prove their case, but is very predatory in terms of sort of the connection of the alleged victims in the case. Okay, so that's one issue that is the court. One of the other things that the court takes into account, because, unless there's been some prior behavior on the defendant in terms of that they're going to, that they have fled or not appeared for a court proceeding or those kinds of things where the court can see past behavior directly related to the court. One of the things that the court looks at is, does the individual do things that in the court's mind may either lead or obstruct an investigation or do something that might be obstruction of justice? So that's something that, and I would tell you that the court looks at that. Where I weigh it depends on the particular case or the nature of the case.
Do you have an example, Your Honor, of what you're talking about?
Well, if you look through the prosecutor's response, there were, and I guess I wanted to get the defendant's response to it, which may just be it didn't happen, but there are indications that during, and at what point in the investigation, I'm not sure, that there were calls or communications from your client to individuals that are now alleged victims in this case, to, if they're contacted, to not say anything, or contacted to support the defendant.
Right.
And there were at least 2 or 3.
And what I would say, Your Honor, is there's
Go
cell
ahead.
phone records that should exist. My client called them or vice versa, then the cell phone records that in 2024, pretty good. You know, if the prosecutor's office thinks that my client was calling them and telling them that, then produce those records to say,
Well,
here's X
but
number.
counsel, you know, I get it, but I'm not at the point of prelim or that. I'm looking, you're asking me to reduce bond. There are certain things that I'm looking at that I'm telling you that cause the court alarm. And one of those things is, if that happened, that's a huge red flag to me. And it sort of counter, or at least counters one of the things you said about the existence of evidence in his home or not in his home. Because at some point, what's clear to me is that at some point during the course of this investigation, the defendant became aware that something was afoot. And I'm putting it that way because I don't know if he became aware he's under investigation or became aware of whatever. It may have been, maybe he was contacted by the FBI. That was the initial part of this, whatever. But then it wouldn't make sense to me why he would be, at least that's what's alleged here, contacted by these individuals or contacting these individuals to say, do X or do this. I mean, the statements that are in there they're not, well, we talked to police, tell them the truth. They're not sort of these innocuous things. They're sort of directives of what the individuals should do.
And you said it quite clear. If it's true, if the court doesn't have any evidence of that other than what's written on a piece of paper, and if they wanted proof of that,
but counsel, that argument is fine, except, you know, I need some type of response to that, because it can't be, well, do the people have this evidence? Because if that's the case, if I take your analysis, that means in every case, despite any rule, despite anything, people just get released on everything. I realize that this is something that is fluid and that evidence kind of moves along. But I'm asking at some point, maybe the prosecutor argues first and then you can respond to it. But if you look at the particular provisions in the prosecutor's response, there are indications at the end of a few of the paragraphs where they're talking about the victim or alleged victim being in contact with your client, and that there is then the allegation that there are specific instructions about what that person is to do when contacted. So I'll let you look at that, counsel, and I've got it as I
can I ask exactly where, what page is that on that you're looking? I've read through this a couple times, so I know it's in there. I just don't know where it's at.
For that portion. Right, I don't know if you can help me. There were 2 of them. Oh, victim DNB is one, and the next one, victim E, the reference at the bottom,
Is there a page number here?
page 5.
Page 5 with victim D and victim E. And I went back and I've looked at these things. And again, Judge, if the court has any, any concerns regarding my client with that type of contact, the one thing I would remind the court of, one, if it did happen, then I would say, obviously he wasn't under a court order or anything at that point. And so I understand the court's concern, but we would be willing to, have no contact orders, take away, and give up on any electronic devices, no phones, no computers, none of that. And I think that would obviously put to rest any possibility of him. And obviously, if he violated that, he would be right back here in jail. It would not be wise for him to do that. It wouldn't be wise for him to contact that. And honestly, Judge, it would be contrary to what I would advise him to do.
Well,
So
right. And let me make myself clear that I'm not saying that he violated a condition of bond. I'm not saying anything along those lines. I'm saying what troubles the court is that behavior where there are these allegations that are out there, and then behavior to, so I'll put it in the colloquial, just to either cover up or interfere with and or obstruct an investigation. That's what bothers the court. I'm not saying that he should be charged with anything. I'm not saying that. I'm just looking at the behavior of the defendant, because that's what I've got to bank on if he were to be released. And I'm pointing out what at least is alleged, a behavior that is very troublesome for the court.
does this go to risk to the community, Your Honor, that you're talking
It
about?
certainly goes to risk to the community, and in my experience, also would go to the issue of, can I trust this person to not flee? Because in some way, this can amount to some type of obstruction of justice or some type of interference with an investigation. And do I believe that that person, assuming, and I'm not saying, not trying to necessarily make an accusation, but if somebody were to do that, can I trust that person not to flee the jurisdiction?
And again, Judge, I'm sure you've been doing this a long time. I've been doing this an awful long time myself. I've had, this is not my first bond hearing. I understand the court's concerns, and under the circumstances when you have somebody that's got no prior criminal history whatsoever, you've got somebody that's never lived outside of Michigan per se, other than being in Virginia for Liberty for school for for whatever that time period was, that has lived here his entire life. His entire family resides here. He doesn't have a passport, so it's with the lockdowns that they have today, I mean, it's probably pretty impossible to try to get off out of the United States without a passport. And obviously going anywhere else in the country, with the computer system, the NCIC, and everything else that's out there, makes it almost impossible for somebody to just disappear and never be found again. It doesn't happen. I mean, I don't think I can think of one case where I've ever seen as an attorney where somebody didn't show back up.
But counsel, it isn't even the issue of will they be found again. It's the issue of will you attempt to try to flee the jurisdiction. I mean, and it's a slight distinction, but there's a distinction in it. So
I'm just saying, Your Honor, with the bullet points that I've already presented to the court, that he's not an alcoholic, he's not a drug abuser. He's had a job his entire life. He's got family and friends here. There's nowhere for him to flee. He's not going to flee. I don't think the court has anything to worry about with the fleeing portion of this. And I don't say that lightly, Your Honor, because I understand the severity of these charges. I get the concerns of the court, and I don't take that lightly. I don't take my position as his attorney lightly in that matter. And so, I drive 2.5 hours to get here every time I come here. I certainly don't want to represent a client that I would think is going to flee the jurisdiction and not do what I'm telling him and directing him to do. I certainly would direct him to make sure that he's in court. He knows what the evidence is at this point, Judge. And I told him, obviously we're here to defend this, and he's here and he wants to defend it. And obviously that is our goal, is to get through these PCCs, get through the preliminary examination, and let the chips fall where they fall. When we get through the preliminary examination, then if any charges that still exist after a preliminary examination, then we'll deal with that in circuit court. So obviously, our position is, Judge, is that he's sitting in jail for 105 days. The evidence in this case just, to charge people with CSAM and not have any CSAM just doesn't make any sense to me. And then to file more charges for the same charges without knowing that you didn't have any CSAM doesn't make any sense to me either. So in light of all that, Your Honor, just the magnitude of these charges that are presented on top of him doesn't mean that, hey, there's more charges I'm going to take, possibly be a flight risk or a danger to the community. He wants to face these charges. He wants to exonerate himself. That's what he wants to do. And so with that being said, Judge, my client is going to appear for these court dates. He's going to appear with me. And again, he's got all these people that are supporting him. He's got the letters that were presented to the court. He's got a place to stay, and we will give up any electronics. We will give up anything the court wants. If you want to put a tether on him, we'll do the tether. We'll put him, no contact orders. Take away all electronics. Anything that the court would make it feel safer for him to be out. He's going to get a job, and he's going to go to work, and he's going to live with his family. He doesn't need to have access to any of that stuff. So the court can put those no contacts, and if he violates, then throw him back in jail and keep him there. I have no problem with that.
All right. Thank you. Ms. Rice.
Thank you, Your Honor. I would indicate to the court that the defendant was arraigned and arrested on or about October 20th, 2024. At that time, Magistrate Fink set the bond at $3 million, no 10% cash or surety. Once the defendant was arraigned, additional victims did come forward. At the time of arraignment, he was charged with 1 count of criminal sexual conduct in the first degree, with 1 listed victim and additional approximately 11 additional counts of child sexually abusive activity and using a computer to commit a crime with different victims than the listed victim for the criminal sexual conduct first degree. When the additional victims came forward, the defendant is now, after the arraignment and the bond being set at $3 million cash or surety, facing 6 additional counts of criminal sexual conduct in the first degree with 2 separate victims. And I state that because the court rule in the statute allow this court to deny pretrial release of a defendant charged with criminal sexual conduct in the first degree if the court finds the proof of the defendant's guilt is evident or the presumption is great, unless the court is presented with clear and convincing evidence that the defendant is neither a flight risk or a danger to the community. And I would submit to you, first and foremost, Your Honor, there was no abuse of discretion in the magistrate setting the bond at $3 million. But if we're going to look at the bond that was set at $3 million, the things that have changed since that bond was set is additional victims have come forward. So it would not be appropriate to reduce the bond. And in fact, the people are requesting that the bond be denied because there's no clear and convincing evidence that the defendant is neither a flight risk nor a danger to the community. This information in the investigation began on or about August 26, 2024, when it was reported to the police department, to MSP. One of the victims reported to the defendant's girlfriend at the time the things that the defendant had done to him. When his girlfriend at the time confronted him about that, confronted the defendant, she had a 6-hour-long conversation that night discussing the victim that had come forward. The defendant told her not to believe a word that he said, and he left her house around midnight. He told her that it was best that she not tell anyone that the majority of their conversation was about that victim. And he reminded her that they still had a 2-week break left in their relationship. and not to contact him. Another victim came forward, and that's when she broke up with him. After that conversation, on August 30th, 2020.
Excuse me one moment, sir. Counsel, when you want to talk to your client, make sure to push the button on the top.
Yes, sir.
These microphones are very sensitive and I don't want a conversation. All right, go ahead. Ms. Rice.
On August 30th of 2024, the defendant then called that victim 8 times and told him that he needed to keep his, quote, fucking mouth shut, end quote, because there was no information that he could tell Brianna. And that's referenced in page 8 of the people's motion. So this is information that the defendant, that we have during this investigation. This is how he's acting when he's not been charged, when he's not been arrested and not been arraigned. He is intimidating and threatening the victims. And I would submit to this court that he is a flight risk. During the investigation, on October 21st, 2024, the Michigan State Police interviewed the defendant's parents. He was informed by the defendant's parents that the defendant went to Virginia after news of this broke. He may have stayed with his college friend Phil, whom he knew from Liberty University. His mom thought that she went to stay with her sister Rhonda in Indiana after he left Virginia and gave Rhonda's address. Rhonda dropped off 2 suitcases of Zach's to Frank and Robin. Frank went through the luggage and found a MacBook inside. The trooper took custody of the laptop. Robin and Frank did not know the passwords to any of the devices. The defendant's mom cried during the interview and said that Zach had been leading a double life.
Counsel, I don't want to interrupt you, but I want to make sure that I'm understanding this. In October of 2024, the defendant, after the investigation starts to happen, he leaves the state to go to Virginia.
Correct. Around the time that the news broke, but before he's been arrested or arraigned, he left and went to the state of Virginia.
Okay, so when you say the news broke, when it became public.
I don't know exactly when they referenced, but I'm presuming sometime in the end of August, beginning of September, when everyone in the community, the church community, and the victims started coming forward and reporting to the police.
Okay, and so he left the state, some thinking that he's in Virginia, others thinking in Indiana. Irrespective of that, for how long a period in time was the defendant not in the state?
I don't know the answer to that. They had just started to take the investigation and interview these victims. And when he was ultimately arrested, when the police arrested him after the conversation where he made admissions to one of the mothers about having these boys send him pictures of themselves masturbating, and he would pay money for them, when he made those admissions that are on tape that will be played at the preliminary exam, he was driving a rental car and had multiple electronics in the rental car that were seized. So that is our evidence, our indication that he is a flight risk. So
and I'm sorry, but the rental, or he was arrested in the state of Michigan.
Correct.
All right.
In
a rental vehicle.
Dundee. In a rental vehicle.
In Monroe County, down in Dundee?
Yes.
All right, go ahead. I'm sorry.
So that is just some of the information that the people believe that the court can consider and show that he is a flight risk. Beyond that, Your Honor, counsel talks about just because of the number of charges that the people bring doesn't affect bond, and I think it does. In this case, the allegations are, and the evidence will show, that the defendant abused his position of authority at the church. So it's not, we don't have one victim or 2 victims, we have multiple victims spanning over a year period of time. So he is a danger to the community, and the people's position is, if he were released, he would be contacting these victims, and there's nothing to stop him from contacting. Sure, there's a court order and we can violate his bond if he does it, but the appropriate thing in this case, and the multiple counts of criminal sexual conduct in the first degree, allow for this court to deny the bond. And that's what we're asking be done. The statute, the jury instruction on criminal sexual conduct in the first degree concludes that to prove this charge is not necessary that there be evidence other than that of the victim, if that testimony proves guilt beyond a reasonable doubt. So the victims of the criminal sexual conduct can come here and testify at preliminary exam. They can testify at trial, and the defendant can be convicted on it. There's not one victim of criminal sexual conduct in the first degree, but there are 3. And so I don't believe it was an abuse of discretion to set the bond at $3 million. I do believe, based on the evidence in this case, that he is a danger to the community and moreover, a danger to the victims in these cases. So I don't think it should be reduced. And we're asking that pursuant to the statute and pursuant to the court rule, that it be denied.
Thank you. Response.
Yes, sir. So going back to the arraignment when he was actually given the $3 million bond, obviously the court didn't have access to what we've given the court, which is the doctor's report for one, you know, the letters of support and all these other things that are out there. 2, you know, there was no discovery that had even been conducted at that point. So whoever the attorney was that was arguing on behalf of my client at that time didn't have anything really to hang a hat on to make any kind of argument whatsoever at that time. But some of the things that the prosecutor just said in regard to this investigation in October, she doesn't know what the dates are when he was gone, when he came back. He came back to face the charges. He wasn't arrested somewhere else. He drove back here to face the charges. So he's not a flight risk. If he was a flight risk, he would have stayed where he was at. He obviously came back here to do the right thing, and that was to face the charges. And he cooperated with law enforcement. There is absolutely nothing that the officer in this case wrote in his report to say anything other than, he was cooperative. If he was a flight risk or if he didn't cooperate with at the time, that would have been written in the reports, and it's not. It's not written in the report anywhere that he was uncooperative or anything else. He absolutely came back and faced the music and got arrested, was even in the front seat of his vehicle, handcuffed in the front, from what I recall. Maybe he was in the back, I don't remember. But obviously he came back, to face the charges. So he is not a flight risk. And again, he doesn't have anywhere else to go. As I said to the court already, there are so many different things the court can impose. You can take his driver's license away, you can take electronics away, make no contact order. He is not a flight risk. He's not going anywhere. And again, going back through the answer to,
well, what was he doing in Virginia? And how long was he in Virginia? And did he end up in Indiana? And how long was he in Indiana?
You probably got to drive through Indiana to get to Virginia, I think.
No, being a Maryland Terrapin, you don't have to do that. In fact, you stay as far away from Indiana as you can.
I'm not from here.
So, So what was he doing in Virginia?
And he just reminded me what he went down there because I think that he had friends that were in Virginia, and he went down there to visit a friend, and he came back. So it's like a vacation that he was on, which is allowable, Judge. I mean, if you're not under.
I'm not saying it's not allowable, but counsel, you're leading this court to believe, and I'm not saying it may just be semantics, but you're saying to me he's only resided in the state of Michigan. I get the whole schooling thing, but that's not true. He resided in the state of Virginia. Then when all of this is at least brewing, from what I understand, and is out in the community, he then takes back off to Virginia and or Indiana for at least some, I don't.
From my understanding, it was only a week, Judge. It wasn't even, I don't even think it was a week. Because he was back here, I think he was arrested on the 20th of October was the arrest date. And I think that it was, it was only for a few days, maybe from the 15th of October to the 20th, something like that. Might have been a little longer, but I'm not sure what the dates were. But I know that he drove back on his own accord and came back. So there's nothing that anybody can say to the contrary to that. And, if he drove back here knowing that there was an investigation going on, if he was going to be a flight risk, then why would he drive back here? His intention was to go to Virginia and say, I'm not going to face the consequences. And why didn't he just stay there? He came back to face the charges. So, the flight risk thing doesn't work. And again, Judge, I'm not trying to play semantics on the court whatsoever.
No, I'm not saying that you were trying to play a game with it, but I'm just saying, by interpretation, certainly, of what you're telling me, gives me a different picture. That may just be how we view the world. That's fine. But prosecutor does bring up a good point, and I don't know what your response to that would be, that at the time he's arraigned, there are a certain number of charges that are pending. The bond of $3 million is set based upon those charges. Additional charges are then filed. His bond remains the same. They don't ask at that point to up the bond. But as it sits before me right now with basically these competing motions, given the charges, and it kind of shifts in terms of one's burden, why wouldn't I grant the prosecutor's motion to deny bond unless I have before me something that is clear and convincing that he is not a flight risk and that he is not a danger to the community? Why wouldn't I do that?
And I would agree 100% with what you're saying, Your Honor, except for the fact that all the bullet points I've already presented, I don't want to beat a dead horse here, but again, if you look at the answer in her complaint, that she can either admit or deny, for one, the meat and potatoes of my argument in 6, 7, and 8, she doesn't admit or deny any of those. So if you can't deny them outright, then your case must not be that strong if you can't deny it. She obviously doesn't have the proof.
Yeah, but that's not my standard, is it? Under the rule? I mean, the charges have been brought, and if I believe that there's a likelihood of conviction, then certainly I can go one way. But on the charges, certainly I could deny bond unless there is clear and convincing evidence that he does not pose a danger to the community and or flight risk.
Right.
And I'm getting, and counsel, and I'll just tell you, I mean, I sit here and I cannot certainly predict the future. That is not my job. But I certainly have to look at a person's behavior to try to assess what is the likelihood that that person will do it. And I'll be honest with you, I'm not getting really satisfactory answers to his whole Virginia connection, to where was he? And you're saying it's a vacation or whatever, but okay. And the contact with individuals and what he's saying to those individuals, knowing this is going to happen. I'm a bit hard pressed to say that that person doesn't pose a danger to the community in terms of what he will do. But I'm more than willing, I mean, I'll stay here as long as I have to. I'm more than willing to hear all of that. But those are things that go to those core issues of, does he pose a flight risk? I understand he has no criminal record, so I don't have that. But when all of this is going on, why does he take off to Virginia? And then these people, maybe this is wrong, who are so close to him, they're not really sure where he is. Is he in Virginia? Is he in Indiana? Cheap suitcases for 5 days? I don't know. But depends, I guess, on how you pack.
I didn't leave my wife before either.
Pardon? Well, yeah. But that's a problem for the court.
Well, the only thing I can say, Your Honor, to this is this, if the guilt was evident and the presumption was great in this case, we would have way more evidence to look at.
But
don't have-
But counsel, here's the thing. As Mr. Reiser is pointing out, if one of these victims gets up and says, this happened to me, and lays out a series of events and series of facts, then certainly he could be bound over to stand trial. And certainly a jury could convict solely on that. I mean,
you convict on circumstantial evidence. I don't disagree with you, Judge. Circumstantial, I can make an allegation against anybody.
correct. But then counsel, and I get that the number of charges don't matter. But what the court also, in looking at that particular issue, does have to take into account is the people's rendition in their motion. There is this repetitive predatory behavior. Realistically, as our society is under circumstances that are really troublesome because of his position and these young adults. But it's not just one. I mean, there are just these numerous people, like victims, but an odd commonality to what they're saying. And maybe not so odd, but there's certainly a commonality as to what they're saying. That's anything else you want to say as to, under the rule, as to whether or not the court should strongly consider the people's request that I deny bond? Is there anything else you want to say?
Your Honor, I just think that, based on what I've already presented to the court, with the low risk coming from a doctor in your jurisdiction, that maybe he's even been in front of this court, I don't know. But I mean, obviously she put him as a low risk. I think that should weigh heavily on the court. I think that, his prior record, the fact that he doesn't use drugs or alcohol, that he has his entire family here, that he could get a job, that we're willing to let you take the electronics, no contact order. I think that,
if he got a job, counsel, what would he be doing?
he does music, Your Honor. I mean, he could,
Would he be around people, young people? Or people younger?
Not have to be around any young people, and the court could order him not to be around. That wouldn't be a problem. It's not any problem whatsoever. If you want to put him on house arrest, put him on a tether, he's willing to take that as well. You take his driver's license away and make him have to get driver's license.
I'm aware of what I should or could do.
I'm just saying that, Judge, there's ways that the court could obviously make sure that if he bonded out, that there's not going to be a threat to the community and he's not a flight risk. And I think that we've submitted many letters of people that have known him his entire life, friends and other people. I mean, he's got a whole courtroom of people on this side over here that are here to support him. And, and just the fact that he came back from Virginia and drove back here, which he didn't have to do. If he was going to be a flight risk, why would he do that? he's here. He did not try to stay gone. He came back saying, hey, I got to go back up there and I got to pay this community. And he came back. And that should be the telltale right there, Judge. I think that, weighing these factors into place and going, okay, well, you might be a flight risk. Well, anybody can be a flight risk, anybody. You could have a, spitting on the sidewalk charge and be a flight risk. But, I understand because of the type of charges that we're looking at, it's going to be scrutinized much harshly. And again, I think that we presented enough to this court, and getting a doctor to come in and see him in the jail and going through all these different things that we did. And again, this is my first try at a bond with this court. I didn't represent him at the arraignment. This is the first time it's been addressed in almost 105 days. So, this is our first shot at, asking this court to reconsider a $3 million bond. This family doesn't have $3 million to post a cash bond on this type of case, Judge. And, again, it's tantamount to no bond. So, and it's not
which can be appropriate in cases like this. You keep saying that, counsel, but I mean,
if the evidence is great and the presumption is great, if the guilt is evident, then yes. But again, Judge, you've even said that it's a circumstantial case at this point.
I haven't said that.
Well, I'm saying this.
I did not say that.
I know. I didn't mean to say. I'm saying that it's a circumstantial case at this point. And so, if the evidence was overwhelming at this point, where we had all this stuff that was just coming at us left and right, obviously, I would be in a very different position. If I didn't think I, had to hang up here, I wouldn't be doing this right now. But I've looked through all the evidence. I've seen what they have. And I mean, obviously, my client's innocent until proven guilty in this case, and he has a right to go to trial if he wants to go to trial. And obviously, he has a right to go through the preliminary examination, and we're going to hear from witnesses. But again, putting a $3 million bond on a case where there's not any CSAM and there's 33 counts that involve CSAM, or a lot of them anyway, not all of them, but it's just one of those things that I think the court should consider, that a reasonable bond in this case, which is guaranteed by our Constitution and the Supreme Court the Court of Appeals of Michigan, the site that I cited to the court earlier, guarantees you a reasonable bond. And if the guilt is not evident and the presumption is not great, then you have to move on to the next prongs, which is whether he's a flight risk or danger to the community. And then even if the court deems that doesn't mean no bond. Obviously you could put a higher bond on him, but again, an unreasonable bond for a guy that's indigent at this point. He doesn't have, his truck got repossessed. He doesn't have a home. He doesn't have anywhere to go. All this stuff is gone to four winds. He doesn't have a phone or anything else. He doesn't have a computer. He doesn't have anything. So he's indigent at this point. His support is coming from outside influences, outside people or whatnot. So he doesn't have two nickels to roll together. So at this point, Judge, what I'm saying is that I think the court should look at all those factors that, it takes to be a flight risk. You got to have money. You got to, people don't pick up hitchhikers anymore. It doesn't work that way. I'm asking the court to consider it. I think that our request for a lower bond is reasonable based on the circumstances.
Anything additional from the people?
I do, Your Honor. I do. It is not disputed that after these allegations started to surface, but before the defendant was arrested, that he left and went to Virginia. Whether he went there for vacation or to dispose of evidence, he left the state of Michigan. When the defendant was arraigned and charged, additional victims came forward. And I'm going to provide the court with an offer of proof of what one of those victims will testify to. And at the conclusion of that, I will ask that his bond be denied.
Go ahead.
The victim was jealous of Zach because Zach was a cool guy of the church. Everybody talked to Zach, and he seemed like he was a safe space for people. The victim got an iPad Touch for Christmas when he was 14 years old, and he got Snapchat in February of 2015. His parents did not want him to be on social media, but he defied them and got a Snapchat account anyways. The victim's handle on Snapchat was this. Zach, the defendant, added the victim on Snapchat, and they talked on Snapchat. Around June 2015, the defendant asked the victim on Snapchat if he had abs, and he asked for a photo of the victim shirtless. The victim sent the photo, and Zach told him to delete the photo from his phone. The victim did this. A few days before the first incident, the defendant asked the victim on Snapchat if he knew what a blowjob was. At that time, the victim kind of knew what it was. The defendant asked the victim if he would ever want one. The defendant offered to go on a drive with the victim and they could listen to music and talk. They hung out alone only on 2 occasions. The first incident was a Saturday night in July of 2015. The victim was 14 years old. He remembers this day because he went to church the next morning. On Snapchat, the defendant asked the victim if he had ever gone out late at night. The victim was bored and wanted to go out. In the middle of the night, the defendant drove to the victim's house. The defendant was driving a smaller sedan. The victim snuck out of the house and he got in the defendant's car. The defendant was in the driver's seat and the victim was in the front passenger seat. The victim remembers where they drove, on Calder Court, and parked on a street south of Harper Drive, so they were still near the victim's house. The victim was wearing loose shorts and he was a virgin. The defendant put his right hand on the victim's left thigh and began to rub it up and down his leg. The defendant asked the victim about blowjobs. The defendant made it seem like blowjobs were a thing that he did with his friends. He called them bro jobs. The defendant touched the victim's penis over his short and with his right hand. The defendant used his right hand to pull down the victim's shorts and underwear to his feet. The victim said he froze out of shock because he didn't know what to do. After the defendant pulled his underwear and shorts down, the defendant touched his exposed penis with his right hand. The defendant leaned to his right and put the victim's penis in his mouth in a sucking manner. He sucked on the victim's penis for 3 to 4 minutes. He stopped sucking on the victim's penis when he ejaculated in Zach's mouth. The defendant asked if he was okay, and the victim said he did not know. The defendant asked if it felt good. The victim said he felt weird. The defendant told the victim he did not have to do it again, but he wanted to give him a space to feel good. The victim asked if he could go inside. And the defendant was okay with that. So the victim got out of the car and went back to his house. Said he could not sleep that night. The next morning he had to go to church and Zach was there. They did not talk about what happened the night before. His parents didn't know he snuck out. The victim said he was scared because Zach was a bigger guy. The second instance occurred in 2016 when the victim was 15 years old. They were still on Snapchat, and the defendant alluded to engaging in more sexual activity, but the messages did not use the word sex. The victim would confide in the defendant about getting in trouble with his parents, and the defendant picked him up in the middle of the night. He instantly came down to get the victim. In the same sedan as the incident before, the defendant was in the driver's seat, the victim was in the passenger seat. They drove to Oakwood Church's building, currently the Washtenaw Christian Academy. They pulled into the parking lot. The defendant asked the victim if he'd ever given a blowjob. He said he did not. He kept pestering about giving a blowjob, and the victim was hesitant and told the defendant he felt weird. The defendant pulled his own pants down and said that the victim should suck his dick. And the victim said, I don't know if I want to. The victim froze again and the car was silent. A few seconds later, defendant started masturbating while the victim was sitting there. The defendant whispered to him, you should help, and the victim didn't move. The defendant put his right arm around the victim's shoulder and neck. The defendant pulled the victim toward his lap, and he felt like he did not have a choice. The victim sucked the defendant's penis for about 2 minutes. The defendant had his right hand on the back of his neck, and if he tried to sit up, the defendant pulled him back down. This ended when the defendant ejaculated in the victim's mouth. The victim turned to the right, opened the passenger door, and threw up. The defendant asked, why'd you do that? And the victim did not respond. The ride home was silent. He dropped the victim off. The victim did not sleep that night. He had nightmares. He was scared for his life because he thought Zach had a gun. Before this, he said Zach always had a gun on him, but he did not see a gun on this night. His parents didn't know about it. They forced him to go to church. He would see the defendant at church every time. The defendant would tell the victim they shared a cute little secret. In a span of a few months after the second incident, the defendant texted the victim to see if he wanted to meet up, but the victim declined each time. Then the defendant started to ask him for videos of him masturbating. He didn't send any. The defendant in June of 2015 asked the victim if he could ever send a nude photo before. The defendant offered to send the victim a photo of him. The defendant said he would pay him $20 for the photo, so the victim sent the defendant a photo of his penis on Snapchat. The defendant gave him $20 cash for the photo the same night of the July 2015 incident. During the trooper's interview of the victim, he teared up, his body shook, and he took a deep breath and long pauses. He said these events were hard to talk about. We're asking that the bond be denied. That's one victim's testimony that I anticipate you will hear at this preliminary exam.
Of course, we're going to take a brief recess, read over the documents, the letters that you sent, make sure I have that, take a look at it. I will come back and give you 14 minutes.
All right. 14A District Court for County of Washington State District is now back in session. The Honorable Judge Simpson presiding.
You may be seated. Back out. We're back on the record in the case of the People's State of Michigan versus Zachary Radcliff. In this case, there are, in essence, competing motions regarding the defendant's bond. The defendant is asking that his bond be reduced, and the people are asking to the contrary that his bond be effective, well, not effectively, but denied in this case. The court rule is very clear and very specific in terms of when the court can deny bond to an individual. There's a statutory section which applies to it, as well as a court rule. Specifically with reference to the court rule, the court may deny bond to a defendant that is charged with criminal sexual conduct in the first degree armed robbery, kidnapping with the intent to extort money or other valuable thing, thereby if the court finds proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person, or what one may say, a danger to the community. The court can take a number of factors into account, and I've given, I think, each side an opportunity to respond to the court's inquiry as to what was going to be important in terms of the court's deliberation. People have done, well, both parties have done an excellent job in laying the issues that the court needs to decide before the court. I would say that the people's rendition of the statements and stories, at least the minimal synopsis of the statements and stories of the alleged victims in the case, are indeed compelling to the court. And one of the first inquiries that the court had was, as the court sees the whole thing, what really is a grooming and predatory behavior as you see each of these incidents. The court does take into account also that the defendant's position within the church and access to the youth play a factor in that, as it does in cases where there are children involved and certain behaviors, threats, if you will, enticements, other things can come into play. What is also of note, and something that the prosecutor brought up and I think does bear noting, is that the defendant's bond initially, when the initial charges were filed and the arraignment was set at the $3 million, the current bond that it is set at, did not take into account the additional charges that came forth. So this is really, in essence, the first addressing of bond with the additional charges of the additional individuals. I say that because I want to make it very clear that any change by this court is not based upon it's based upon the motion, not based upon any abuse of discretion by the magistrate in terms of initially setting the $3 million bond. But the rules, in essence, well, defense counsel is correct in pointing out that one looks at an individual's release and their ability to have bond or to be in a position to post bond and not restrict their liberty, except under those limited circumstances. And then it is almost as if and it is up to the people at that point to show that the defendant should be incarcerated. In limited circumstances, that in some ways shifts the burden in looking at certain things, shifts. For example, in a crime of treason, violent felony where the other predicates are met, and then in certain types of cases where there is an analysis of whether guilt is evident or where the presumption is great. Given what this court has heard and the motions that have been filed and the information that has been put before the court does find that there is a great presumption that the people have established a great presumption of the defendant's guilt in this case. I would also indicate that the court is taking into account that the behavior is indicated, at least is laid out here. And I don't know what would happen during the course of testimony, but what has been laid out shows, I don't even want to say classic predatory behavior, but it in a lot of ways is, where individuals are basically put into, these victims are placed into that position. Certain threats, either said or unsaid, are then placed upon these individuals. And then these individuals don't come forth. As the proffer indicated, that was put forth by the people. If that's true, and if the evidence, I should say, bears that out, one can see what the court is talking about with reference to an individual that is a young person who is forced to engage in sexual acts, who is then that next day has to see that person in all places, a church, and that person being in a position of power or authority. Been doing this a long time. That whole concept may seem like it's just something that just happened. Frankly, when one looks at it on the surface, that it's actually, if this is a circumstance where the two incidents, that's all that I had necessarily before me, occurred, that's not by accident. That is, that whole series of things is by design for a very good reason, because that stops this person from saying anything, doesn't say anything to the parents, doesn't say anything to the people in church, doesn't say anything because of where this happens. And the longer that goes, it becomes more difficult for the person to say so. And just listening to that, looking at what's been laid out by the people, the court, as indicated, does find that there is a great presumption of the defendant's guilt. It then shifts to show by a higher standard than normally would be applicable in a bond argument of basically a preponderance of evidence, but it shifts to a clear, convincing standard to show that the defendant is not likely to flee or does not present any danger. And that really does shift, in essence, to the defendant to show that, or at least put forth some evidence to the court where the court could conclude that. This court does not conclude by any stretch of the imagination that the defendant is not likely to flee. The court believes that the defendant is in a position of potentially facing life sentences. That also there is a circumstance, and it's a bit unclear, a bit murky, but where he knows that he is subject to at least an investigation and flees, or at least leaves the state. Oddly, where the parents, or those that most likely would know where they are, where he is, don't know. And he is there. Counsel may make a good point that the very fact that if he were going to flee, that he comes back, under what circumstances and for whatever his reasons are of coming back, I don't know, and maybe that's to be told, but this court views that as something where clearly the defendant has connections in other states that he could flee to. I think that the laying out of the number of victims, and not necessarily the numbers, but the number of the acts, make it more likely to this court that the defendant would flee or could flee to that. And the court does believe that he poses a flight risk. I also do believe, because I think it becomes a bit difficult when one is trying to address, does this person pose a danger to another person and or to the community? This court does believe that this defendant, given all of the circumstances that the court now has before it, does pose a danger to the community. I've read all of the letters of support that the defendant does have, and people have good things to say about him. They have good things to say about his family. I make note of one thing that the prosecutor said, and it doesn't seem like it's much, but for this court, it was much, where in talking with Michigan State Police, she either blurts out or says that her son is leading a double life or a separate life. I don't blame her for saying that. I think it may have just been something that she said when she sees everything. And I think that that's true in this case. And so I also think that there isn't, given the magnitude of what the defendant is accused of in this case, that while the court has many tools at its disposal, the court doesn't have the, I don't think, proper tools that would be able to monitor and prevent the defendant from hurting other individuals or engaging in this behavior with other individuals. The only way the court would have to do anything along those lines is certainly to order that, but that doesn't mean that the defendant has to follow it. And then we don't know until somebody else's mental health and or physical health is damaged that it has occurred. And this court is not going to take that risk given the circumstances and what the court is looking at. Taking all of that into account and looking at everything, and now looking at this case with the number of charges, the number of alleged victims, the court does not believe that the $3 million bond, which was initially set, is an appropriate bond, and that under the circumstances, the court now has heard them and now knows the defendant's bond ought and should be denied. And so therefore, I will deny the defendant's motion to reduce bond. I will grant the people's motion to deny bond. Defendant's bond is denied. We are also set. Go ahead.
Thank you.
We are also set for PCC. Are we ready to proceed to the next stage in this matter, or where are we?
Judge, I was going to ask the court, will you give me will you do a written motion on that order that you just made?
You mean a written order?
Yes, sir.
I usually do not prepare a written order. If you'd like to prepare one, you may, and I look at it and sign it. But I mean, in terms of, there'll be a written order denying his bond. But
No, I understand. I just wanted your written findings in the order that you put on the record.
I'm going to let the record stand. If you want to draft an order, counsel, I will be more than happy to look at it and sign an order if it's appropriate.
Okay. So as far as the PCC goes, again, we just got their supplement report yesterday, number 12, where last time we were doing the 9th, that I had asked the prosecutor specifically if there were any more warrants out. There was not. Apparently there are. There's Snapchat warrant number 1 and 2. Based on that report that I just got yesterday, there's Beth's phone. I don't know what that is. And then she's got also on there that the MacBook Pro, the black MacBook, and another phone. Apparently they're still doing some forensic stuff on that. I'm also going to address some of the older stuff that we previously asked for, which she alluded to today, I think, which is the wired conversation between
what conversation?
Wired. I've looked through my stuff she can direct me to a time or date stamp and a date for that particular conversation that was made between Priscilla and Mr. Radcliffe. I've looked through all my stuff.
Your first name, Priscilla, being
Bert.
All right, go ahead. Oh, I got you. The X in him.
Yep. So there's apparently a conversation that was recorded that I don't have. I don't know if it's something that they've sent and it's in something else possibly, but I pretty much have gone through everything that has been sent, and I have not seen that. And then we've also asked for the victim advocates notes, which were done by Megan Palamita. Whether they're exculpatory or inculpatory, doesn't matter. We're entitled to them, and we have a right to those notes. If any of the victims made statements to the victim advocate, I would ask for those notes. And I previously asked for that information.
So what I have here is I have two things: the wired communication and victims advocates notes. This one here.
Those two things, but also, Your Honor, are we going to get Snapchat warrants? That I thought warrants were no longer in play, but again, we just got the sub report 12 yesterday, which says that these are outstanding. The Snapchat warrant 1 and 2. So I didn't think that there was any more warrants out there for material. If they are, that's fine. I just, I thought that we had already answered those questions.
Mr. Adams.
We would ask that a preliminary exam date be set. I believe that we'll need a separate date because of the number of witnesses and the length of time that it will take. So I would request that it not be set on a Tuesday with other exams because of the number of victims that are set that will be testifying, I should say. The recording should have been sent, and I'll confirm with our discovery clerk if it went evidence.com or if it's something that counsel needs to pick up, but it is item 22. The recorded conversation between the defendant and one of the witnesses. So he should have that, and I'll double check. And the
so you believe what's been referred to as the wired communication has been sent?
It should be. I don't know if it went on evidence.com. It's listed as item 22. So I have to check with Ms. Warnick because she sends everything out. I don't know if it was mailed on a DVD, but that should have already been
gone too. Okay.
That's it. I don't believe, I don't have, and I don't believe that the victim advocate's notes are discoverable. So I would ask for some authority on that. I don't know how they would be relevant.
I don't know how they would be discoverable either. Do you have anything on that?
I don't have. I think I may have something, Your Honor, that I can forward. I could file something as a supplement.
That's fine. I mean, on first blush, I almost look at it as though it would be getting an attorney's office personnel notes regarding conversations that they have with clients. And it would seem to me on first blush, I'll give you an opportunity to get something to me, that's going to be privileged information and that wouldn't be released. So subject to getting anything else, that's going to be my ruling, that those notes that with regard to victims from the victims advocates would be privileged communications because of their contact with the prosecutor's office and their work product, which may be part of the prosecutor's office. So that's the theory that I'm operating, but certainly counsel, feel free to file whatever is necessary. I was a bit confusing at the last hearing because I wasn't sure what warrants we were talking about, but I guess counsel has just received another report.
Supplement 12 is not a warrant. Supplement 12 is an interview with a witness about a conversation. Supplement 12, January 13th, 2025. A witness called to talk about disturbing comments that the defense father made. That's supplement 12. It has a journal, but it's barely a page long.
Oh, hold on,
report was sent over there.
Hold it, because I want to make sure we're talking about the same thing, because when I listened to Mr. Thomas, it sounds to me like you were saying there was a warrant out. Information came back from that warrant.
Oh,
Created a
Yeah.
report.
CCU forensic analysis of the defendant's devices. I don't know the time limit on that. If we don't have passcodes, we could.
No, I get that, but I want to make sure, folks, that in regard to number 12, that we're talking about the same thing. Because as I understand what Mr. Thomas is saying, and correct me if I'm wrong, Mr. Thomas, it seems to me he's saying that there was a warrant that was out, that warrant netted certain information that then was placed into some supplemental report, which was just produced.
Right. I think it's at the end of 12. I looked at it briefly. I know it said something about the Snapchat warrants were out. It's I think toward the end.
So the supplement 12 is maybe 2 paragraphs. It's a witness that called to talk about some disturbing comments that the defendant's father made at 125. Status open, the case is open, pending the CCU's forensic analysis of the defendant's devices. There is something they're trying to pull off Beth's phone and search warrants for Snapchat 1 and 2. So those are outstanding things that the police department is waiting on, if you will.
Got it. Okay. So that's how I get to the Snapchat. The best. Okay. Now I think I understand.
The search warrants have been served and we're waiting on the return.
Waiting on the returns. Got it. Okay. Now I think I understand. So there was a report generated. At the end of that report, it just lists what else is out there that everybody's waiting on.
Correct.
And that's where the snap. Okay. Now I see where we are. So with that, counsel, I mean, I can set a preliminary exam date and what comes through, and I'll entertain whatever comes at that moment, but I don't know what's gonna, I have no idea what's gonna come of that. But what's your preference in terms of?
I'm fine, Judge. I think that, what I don't want is to get hit at the last second with a piece of evidence that we didn't get a chance to look at.
Preliminary examination in person will be set February 24th, 2025, 9 a.m. and that is before me. As indicated, is denied after hearing.
Thank you.